EC was represented in court. Sammy Gyamfi is a communication officer with the NDC, a lawyer himself, and we are privileged to have you in the studio. Sammy, you're welcome.
Thank you.
So, your reaction to what happened in court today before we deal with the matters one after the other?
Well, first of all, today was a very important day.
Right.
But even before I go on my reaction, let me state for those who are watching who may not know the gentleman who just spoke to, that he is not just any legal practitioner. He is not a neutral voice on this matter. He's a staunch member of the ruling New Patriotic Party. He attempted to contest the NPP primaries in Infanseman in the year 2008, had to even sue the party, and the Honorable Member of Parliament for that, Asabi, at the time in court. So there's a staunch member of the NPP. There is nothing wrong with that.
Absolutely. I mean, he was only providing his legal understanding of what happened in court today.
Speaking. Again, he is an appointee of President Akufo-Addo as the council chair for the Dombo University in the north. So, an NPP appointee. In fact, Akufo-Addo protege, because he trained in Akufo-Addo chamber as well. So let's go to his view on this matter is colored. It is not a neutral or impartial view, and it is something that we need to place on record. Now, on the proceedings of today,
right.
First of all, we need to commend the trial judge, Justice Efiasewa, for delivering that detailed reason judgment. Bear in mind that the judge had less than 2 days to put together such a comprehensive ruling.
But your news conference was last week.
Yes.
So we are just like less than...
No. You know, we went to court
yes, of course. I remember.
Tuesday,
yes, exactly.
And she adjourned on those applications to give ruling.
For just 2 days.
So 2 days.
2 days.
So she had Tuesday after court, the whole of Wednesday, and this afternoon she was in court to deliver ruling. We're talking about almost 40 pages.
Right.
Okay. And so as a student of law, as a lawyer, interested in the development of the law, I am excited, and it is something that we need to encourage on the part of the bench. Detailed, reasoned rulings like this help the development of the law. So I commend her for that. Now, number two has to do with certain decisions that the trial judge made, which in our opinion were totally wrong. Because those decisions
specifically
are not borne out by the law and the facts that were before her. So we have several disagreements with her on some of the decisions. The third leg has to do with the other decisions that the judge made, which we agree with, and which are very, very material, very, very relevant for the public to know. So what would you like me to start with, the disagreements or the agreements?
So we'll come to the Attorney General and the advice. First, there was the issue of the applicants were in court asking for certain reliefs. One of them, a mistrial, and then the possibility of discontinuation of the entire process. Let's start with the mistrial. And from what our legal correspondent told us, the judge says that, he couldn't find any law to stand on to pronounce on the relief the applicants were seeking. What do you make of this?
Yeah, it's one of the things that we disagree with the trial judge on, because we think that the court had the jurisdiction and the power to make an order for mistrial or an order for inquiry into the conduct of the Attorney General. And we say so because under Article 140 of the 1992 Constitution, the High Court, subject to the provisions of the Constitution, has jurisdiction in all criminal and civil matters.
Right.
And when such jurisdiction has been conferred on the High Court, unless there is any specific law that expressly ousts the jurisdiction of the court to make orders for mistrial or inquiry, we think that the High Court had that general jurisdiction because you have the jurisdiction in all criminal matters. And so in hearing a criminal matter, the court has a responsibility to ensure that these processes are not abused.
Right.
And that the rights of accused persons are respected. And that the prosecution is also done in good faith. And so on. You understand? So if matters are put before the court that shows breach of prosecutorial conduct on the part of, or prosecutorial misconduct, let me put it that way, on the part of the Attorney General. It shows also as the judge herself puts it, conduct that, according to the judge, negates good thoughts. Negates good thoughts.
Absolutely.
Clearly meaning that there is no good faith. And all that. These are matters that the court should be interested in, because the court is there primarily to do justice. And so on the ground that the court has that general jurisdiction on all criminal matters, and except its jurisdiction is specifically ousted, it has that jurisdiction to inquire into matters that are pending before it and all that. We also think that, granted, like the judge said, that there is no specific law or known practice, according to the judge, that confers powers on her to make the orders who were the first accused was seeking from the court. You know that under Article 11 of the 1992 Constitution, which spells out the sources of law of Ghana, the common law is part of the laws of Ghana. A common law is not the laws of Ghana. We are talking about the laws that we borrowed from the United Kingdom. You understand? Right. And under the common law, courts hearing criminal matters have the power to order for inquiries into alleged prosecutorial misconduct. They also have the power to order for mistrial, okay, on grounds of witness tampering or prosecutorial misconduct and so on. You understand? So even if you put the first argument aside, where we are saying that the High Court in Ghana has that general jurisdiction in criminal matters to ensure that these processes are not abused, and prosecutions are being done in accordance with law and so on. You also have the second argument about the common law being part of the sources of law in Ghana, and the common law giving power to cause trying criminal matters to make the orders we're seeking from the court, order for mistrial and inquiries. So when the judge says that, oh, I don't have that power, I don't have that jurisdiction, on the second leg too, we cannot agree with the courts. Then the third leg, I'm coming, hold on.
But when the judge also provide a roadmap and say that some of the matters you are complaining about, that borders on the integrity and the conduct of the AG, there's an appropriate forum that can help.
We'll come there. First of all, let's deal with that disagreement.
The General Legal Counsel.
Let's deal with the disagreement. Then the third leg, why we disagree with the trial judge, is that assuming that everything the judge has said is even true, okay, at least the court should have heard counsel on these important issues of law.
There was nothing like that.
The judge has the discretion to decide whether to hear them or not to hear. But at least the practice is that once you file an application, there is a filing date and there is a hearing date. On the hearing date, the court will usually allow the applicant, lawyer for the applicant, to move the application. It is when the application has been moved that the judge can say, I'm not taking any oral arguments. I will determine the matter on the basis of the affidavits.
On Tuesday, that's what he said.
No.
That she was okay with the written...
application was not even moved.
With the written application.
The application was not moved at all.
Okay.
No lawyer had opportunity to... None of the applicants, whether Dr. Bassett or lawyer Tadio, had opportunity to say, my lord, I have a motion so and so before you press one to this, that. Invoking the jurisdiction of the court for so and so, I move in terms of the motion paper, the supporting affidavit, and exodus. No lawyer had the right to do so. And usually, even on this point of laws, the court may, in exercise of its discretion, it's not compulsory, but in exercise of its discretion, may want to hear counsel on those points of law. Nothing like that. So if the judge says she is not aware of any law, can it be that if she had heard counsel for the applicants, maybe her mind could have been addressed to certain things that she didn't take advantage, she didn't, consider. So that is another point. But you see, the judge, after saying all this, is not saying that the Attorney General is not guilty.
No.
She's only saying that I don't think that this is the appropriate forum. In my view, the appropriate forum is the General Legal Counsel. The judge is not wrong. We are saying the two are not mutually exclusive. The courts could have made those orders for inquiry or mistrial and so on. And the applicants could still have the right, or any person could still have the right to trigger disciplinary proceedings against the Attorney General and the General Legal Counsel. Even beyond that, there are parliamentary processes.
And it's a process already you've indicated that you will pursue.
Regardless of the GLC process,
regardless
is going to be triggered.
Regardless of what the court was going to say.
The GLC proceeding, disciplinary proceedings against the Attorney General to be triggered, but at the right time. I always say at the right time.
So let's talk about the conduct.
The probe will be triggered. There is one that we are also currently looking at about SRAJ under Article 218, which we'll also explore. So basically on that, we disagree with the judge. But it's not only this.
But the issue of the conduct, and of course the judge's comments on the tape, and the fact that she said she had to listen to it 10 times.
Yeah.
And some conclusions she came to on the tape.
Yeah.
And that she was not clear about what the Attorney General said, and other matters relating to JAPA. I mean, the tape perhaps was the foundation upon which all these applications were found.
Let me do a cocktail for you. I will, in answering this question, I will mix the issues we agree with and what we disagree with. Now, listen. What happened today, which is very commendable in our view, is a decision by the judge to admit that audio recording.
Okay.
This is the audio recording that we in the NDC organized a press conference and played to you in the media and circulated it. And you recall what our friends in the MPP said. Frank Davies, Nana Boache, Paul Adomotre, and Highlands of Godfrey Dami said, the tape is doctored. Is that not what they said? It's doctored, it's not authentic. It made all forms of contrived arguments. Now, when this tape was brought to court, they went sash. All the issues of doctrine could not be raised. In fact, the Attorney General himself, who was on that call, could not swear an affidavit. He could not go on oath. Let me put it that way so that the ordinary man will understand. He could not go on oath to dispute anything in the tape. He could not challenge its authenticity or anything in the tape. He had to shift the responsibility to a principal state attorney who was not on the call. He and us were not there. So, then the judge, after everything, says that AG says this tape is not admissible. It is admissible, and I am admitting it. This is a disgrace of monumental proportions. What it shows is that the MPP are a bunch of crooked characters. Liars. They come to the media to obfuscate issues and confuse the ordinary man that the tape is doctored. They go to courts and they behave like cowards. They are not even able to raise the issue of doctrine. And this tape that they are saying is not admissible, blah, blah, blah. You heard them on Newsfile. They could not raise that point in court. Today, that tape has been admitted. That's number one. Number two is that the judge goes on to say that the AG has not denied having the conversation with Mr. Gyamfi. And in his opinion, that conversation should not even have been, they should not have had that conversation at all. And we all know.
Especially when the matter was before the court.
Yeah, and we know the Legal Profession Act, Rule 56 is clear, 56 2D. A prosecutor cannot communicate with an accused person. Then even if you look at the plea bargain law, or even you look at Rule 13 of the Ethics of the Legal Profession, it says that communication with a represented party must be through the lawyer of the represented party or with his consent. That was also not done. Even if you're doing plea bargaining, it must be done with the lawyer of the represented person. That was not done. So the judge said the conversation should not have happened in the first place. Then the judge also goes on to say that it gives the court discomfort that the Attorney General would tell the accused person to contrive evidence of him being sick, a false medical excuse, when the guy was fit as a fiddle. So the judge said that was wrong. And it was on the basis of these findings of facts, because I heard that MPP lawyer, Kwaku Pencil, saying that no finding of fact was made.
Let's stay on the
issues. Yes, I'm staying on the
issues.
A finding of fact was made that the AG is not disputing having the conversation. The judge also said that the conversation should not have happened in the first place. The judge also says that it gives the court great discomfiture or discomfort that the Attorney General will engage the accused person in that manner, seek to suggest to him how he should answer questions, and even tell him to falsify, evidence to come and deceive the court. I'm paraphrasing. I'm not.
But
hold on. I'm going somewhere. Hold on. Let me go. Let me get to my point. So it is on the basis of these that the judge said she strongly advises. She says
not
that
order, not directive.
Courts will sparingly injunct persons who have statutory duties from the performance of those duties. She didn't say that courts cannot do that, but she said the courts are always reluctant to do that. And under this circumstance, she doesn't see the special or the egregious circumstances that should make her injunct the Attorney General, right?
And you agree with that?
However, no, we disagree, and I'll tell you why we disagree. However, she says that she strongly advises that Attorney General should stay away from the case.
Window of opportunity provided, subject to whether the no, I'm saying that
since Ghana became Ghana,
subject to whether the AG will accept or reject. And from what we've been told by the AG, he's going ahead with the case.
Since Ghana became Ghana, from the days of Attorney General Geoffrey Bink till date, have you seen a court reprimanding or advising an Attorney General in whom the prosecutorial powers of states are vested to stay away from a criminal matter?
And that for you,
have you seen something before?
And that for you is a win.
Have you seen something?
And that for you is a win, right?
It's not just a win. At least for me, it tells me that there is still hope of justice in this matter. It tells me that, you see, like, you know, one time lawyer Martin Pebu said that we don't have ADOS in the country.
Yeah.
But I think this shows me that we still have ADOS. Oh, now we are the Bonia, you still need him paying for me. We still have people who, in good conscience, will tell the Attorney General that, look, I'm not going to injunct you, but I strongly advise that stay out. Why will the Attorney General, why would the court do that? Because the Attorney General has been leading this case all along. Why is the court strongly advising him to stay away from the matter? Why? It is because of the disgraceful, unprofessional, and criminal conduct of this crooked character called Godfrey Yeboah-Dame. That is the reason. He's a national shame. He's an embarrassment, a walking disgrace. And if he will not take a cue from this advice from the courts and still insist on pursuing this matter himself, we are even excited about it because we know that he will meet his meter very soon, Richard Japa. And I am praying that Godfrey Dame will defy the advice of the judge. He should dare defy the advice of the judge.
In fact, we have heard him. Maybe perhaps at this stage.
Elton, I'm saying that. Let me end my sentence.
Just a second. At this stage, if we have the AG's response, we can bring it on so that we hear
let me conclude my sentence.
The AG's reaction after the court, whether he will continue with it.
But you should dare defy the advice of the judge, and he will meet his meter, Richard Japa, in the box.
All right.
And bear in mind that this is without prejudice to the other processes, disciplinary processes at the GLC, the parliamentary probe we have spoken about, the trigger of Article 218 and the role Shraj can play in this matter and all that. This is without prejudice to all the things that you want to do. And our clear position that we are pursuing this matter to its logic.
I'll come back to ask you. I mean, you have disagreement.
Some of the comments the judge made.
You have disagreement with some of the rulings of the judge. Is it the case that, I mean, is there room for some kind of an appeal? I'll ask you about that. But what is the AG's reaction to the advice by the trial judge? Let's listen to him.
Where she has dismissed all the applications filed by the first and then the third accused. The Attorney General is working out now. We can engage him quickly. What do you make of the ruling? First off, let's begin with the directive by the judge who advised you to recuse yourself from the ongoing.
Please, stop this sensationalism. I think you remember you were in court. The judge herself, even after the ruling, clarified that she has not given any such order at all. And that is only an advice. And what did you notice afterwards? I'm conducting the matter. I'm still conducting the trial. The most important point today is that all the applications filed by the applicants have been dismissed in their entirety. All the 5 applications have failed. And I think that in reaction to this, I would say that clearly shows there's a group of people in this country who ride on manipulation of facts, distortion, and deception of the public. They're always seeking to mislead and deceive the public. Today they've been exposed. That is what I say. I leave the rest to my friends.
So now that they've been dismissed, all the applications have been dismissed. Yes. How do you see this case going forward?
Well, today, when I was coming, I had a song in my spirit. Head of that church, triumphant. You know that song? Please. We joyfully adore thee. And then it goes on. Precisely. Continue. You have to play it in your radio stations. Head of that church, triumphant, we joyfully adore thee. And I said to you that they will lay traps, but all the traps I'll flee from them. And indeed, only righteousness will prevail.
Right. So that's Ghana's Attorney General, Minister for Justice, Godfrey Yeboah-Dame. Sammy, so I asked a few questions about, so what is the way forward? as we begin to wrap up on this
what
conversation.
we just heard is Key Soap concert part.
That is his reaction.
Comedy.
Let's allow him.
I'm commenting on that. No, it's important. Look at this Attorney General. You engage in clear misconduct, clear criminal conduct, and you are here using Bible verses and Christian songs. He's not even scared of God. Master, God is not a man who go for that. God is not a man that he should be mocked.
So what's the way forward for the NDC? What is the way forward for the NDC and the applicants in
court? You go
court?
and tell a witness, an accused person you're prosecuting, to falsify a fake medical excuse duty to deceive a court. And you have the audacity, the temerity to still quote Bible verses and sing Christian songs. This guy,
Sammy, so
these are the Pharaoh. If this guy existed in the days of Jesus, he would have been whipped like Jesus whipped the
Sammy,
Pharisees.
you disagree with some of the judges' decisions. What is the way forward? What is the way forward? Well, what is the way forward?
Look at this criminally minded
disagree.
person
Sammy, let's stay on the matter.
On the emotional keyboards of Ghanaians.
Sammy Gyamfi, you disagree.
No, I'm scandalized. As a Christian, are you not scandalized that this guy will use the Bible in the name of God to cover up his crimes and his misconduct?
So you disagree with the court decision. What is the way forward?
What a joke.
What steps are you taking going forward as you have expressed your disagreement with some portion of the judge's decision?
Look, the comments the judge made.
Is there an opportunity for an appeal?
About the fact that Mr. Dame said on the tape that he didn't need the help of Jakpa. Yes, I've gone to listen to the tape again. It was around just after the 10 minutes, time, a few seconds after that, where Mr. Jakpa started saying that if I testify the way you want me to testify, I'll be dishonest and I'll be helping you to jail an innocent person. And that will not sit well with my conscience. And that he has been meeting him severally in the house of his cousin. It's true that Mr. Jakpa was the one who said all that and not the Attorney General, right? But what is also true is that Godfrey Dame could not deny any of those averments by Mr. Jakpa, meaning that they were true. Because Dame was on the line. So it was after that Jakpa said, so I can't help you. Then Dame said, oh, I am not saying that you should help me per se. Well, this is just by the way. This is a phone conversation, and I don't know whether I'm being recorded. So the judge, in my humble opinion, got it wrong when she took that statement in isolation. Because you see, when you're assessing evidence and you're weighting it, you need to assess the evidence as a whole. And if you assess this audio recording as a whole, you will see that right from the beginning of the conversation, Dame tells Jakpa to testify his way. That was Dame asking Jakpa for help. You also see that Dame tells Jakpa that if you testify, if you agree to this deal, it creates no difficulty for you. That was Dame asking for help. Other than that, why was he saying that it will create no difficulty?
Is there going to be an appeal? Is there going to be an appeal?
Well, that is something the lawyers are exploring. A decision will be taken on that, and we will communicate that to you. So if you look at the evidence as a whole, right from the beginning of the conversation, you see Dame impressing on Mr. Jakpa to testify his way and assuring Jakpa that it will not create any difficulty for him. And you even see at the tail end, he asking Jakpa to go and falsify a medical excuse duty so that he could travel. He was asking for help throughout that 16 minutes, 5 seconds recording. So if the judge listened to that 10 times and came to the conclusion that Dame was not asking for help, then the judge was terribly wrong, because in many portions of that tape, and if an appeal is filed, all those portions will also be cited. She asks for Jakpa's help, and Jakpa keeps on declining.
I don't think that
again.
Because I just want to ask you, I don't think that we've heard the last of this tape, because now it's been admitted in court. Is it your expectation that the tape will become a key tool in terms of
not just
dealing with the
tape? Oh, you don't know what happened after?
In terms of dealing with the substantive
matter. You don't know what
matter.
happened after? After the ruling was given, Mr. Jakpa mounted the box.
Of course.
For counsel for lawyer Eduji Tamaklo, our own brother, to continue the cross-examination. And Honorable Mr. Eduji Tamaklo sought to tender other tape recordings on the pen drive, a tape recording on the pen drive to evidence. And I want to tell you,
a new one.
I'm giving you breaking news.
Okay.
That there are other tapes.
The other tapes.
Which will be tendered through Mr. Jakpa
You held a news conference, you brought us this one, you kept some to yourself. Why have you...
We told you, we said notice that we have many tapes.
But put it in the public domain. No. You decided to put this one in the public domain.
Crooked characters like Godfrey Dam, you don't put all your cards.
So rather you put this before the court.
No, put it before the court. The court has asked for those recordings to be discovered, to be filed, and all parties should be served, so that if they have any objections, they will raise the objections, and rulings will be given on them. You understand? So there are that 16 minutes 5 seconds tape is not the only tape which will come up in this trial. At least I can tell you. I'm not supposed to do that, but I've told you. You understand? So the point is that Dame's cup is full. This is a man who has been exposed by God. He should stop using God, Christian music, Bible verses to cover up his criminality and unprofessional conduct. What he has done, if indeed he is a Christian, then he is a very bad Christian. He's like the Pharisees and the Sadducees who crucified Jesus.
Let me ask a final question.
Again,
because we are ending.
Need a comment before your final question.
Yes.
Which we totally disagree with. It is about a comment she made that all the parties in the case have agreed that the ambulances that were brought into the country could not be used. That is not correct if you look at the records. Because, yes, Honorable Atoforsen is in court. If you look at the particulars of the offense he has been charged with, for authorizing letters of credit to be established in favor of Big C for the supply of the ambulances without due cause and authorization. So the testimony of his witness, Honorable Setepe, focused on the issue of authorization. Right? Now, Mr. Jakpa, who was the agent for Big C and the third accused in this matter, if you check his witness statement, he goes beyond the issue of authorization into the issue of whether or not there has been a loss. And his testimony was that the ambulances, as they were brought into the country, shipped into the country, were not supposed to be used.
The first consignment.
Yes. Were not supposed to be used is not the same as could not be used. Because they were not intended to be used in that state. Because the agreement was that they will first of all ship the vehicles, which has all those installations and everything. We've shown you the pictures. And then ship the accessories, send their engineers to come down, do the installation, train officers of the National Ambulance Service, hand over the ambulances before the ambulances could be used. And that if the government even proceeded to use the ambulance in that state, they were voiding the warranty on the ambulance.
But I guess
so it is very discomforting that the judge will say that all the parties have agreed that the ambulances could not be used. No, not exactly so. The parties, at least on the part of the third accused, his testimony is that the ambulances in the state they were shipped were not intended to be used in that state because the medical accessories were going to be shipped, and indeed they were shipped. Arrived in the country by October 2016. We've shown you the bill of lading. Were supposed to be installed, cleared by government first, installed by engineers or officers of Big C, officers of National Ambulance Service, trained before the ambulances are used. So that is also another part. But look, the lawyers, the judge has given us notice that we will get the certified ruling by the close of day. We are now commenting on this matter based on what we all heard in court when she was reading what, according to her, was a 40-page ruling.
Yes.
When we get the certified ruling, certified true copy of the ruling, and we take time to study it in good detail and digest it,
you take a decision.
I'm sure that the lawyers will decide on the next course of action. But for us, for me as an individual, it is enough that we have a judge in this country who, after evaluating all this evidence, has come out clearly to say that I'm admitting this audio recording.
All right, Sammy.
Despite all the lies that the audio recording is inadmissible, it is doctored and all that, those cowards could not raise.
Thank you very much. Thank you very much, Sammy Gyamfi.
And the judge has also said that the Attorney General should stay away. That is a disgrace of monumental proportion.
Right, Sammy
the Attorney General should just resign.
Yeah, so the court has a decision to make on all of these, and of course, the substantive matter as well. And of course, we'll bring all that to you here on Joy News. But you've been listening to the communication officer with the NDC, Sammy Gyamfi.